How y'all doing? I hope you guys are healthy. Hope you guys are peaceful. These are definitely some weird times. Thank you for being patient with me with this technology thing. I'm not the best at it, as you can probably tell. So, anyways, this week's topic will be the Supreme Court, and just kind of go through some basic sort of like facts about the Supreme Court, and then we'll dive into a couple high profile cases just as examples. And then that's what we'll do the next segment too, is continue with high profile Supreme Court cases. So you guys probably know this. In some ways, it's the most boring branch of government, only because it doesn't get nearly as much attention as Congress or the presidency. But hopefully I can make this interesting for you guys. So, Supreme Court, you guys maybe have heard how they get there, right? They're nominated by the president, and then they're confirmed by the Senate. That's how you become a Supreme Court judge, right? And there's 9 of the judges, and they're given life appointments, so they're there for life. Now, like going back a second, can you guys think of any issues that might arise when you have a judge who's supposed to be neutral, and their job is to obviously interpret the Constitution, but then the president is the one who basically nominates them? Clearly an issue is going to be like bias, right? So like more liberal judges are going to have, common sense says, right, very liberal presidents are going to have liberal judges, and conservative presidents are going to have really conservative judges, right? So it tilts the interpretation of the Constitution in the direction of whatever president got to nominate the judges. In some cases, presidents get to nominate as many as 2, even 3 judges if they're there for 8 years and there's vacancies in the court. 3 is very rare, but 2, not so much, right? Now, the idea for giving them life terms was to try and keep them out of the pressures of public opinion. So the theory is that if you have elected judges, they may bend to the political pressure coming from their constituents. So they wanted to sort of shield them from that. But as we know, Supreme Court has delved into some super hot button, in the moment political issues, right? So maybe that hasn't worked as it was intended, right? Now the Supreme Court gets about, if you want to have a court, you want to have a case heard, usually what has to happen is, a group of citizens on behalf of one interest or another will file what's called a writ of certiorari. And that's just like a claim, basically like a petition in some sense, a legal petition or a claim. They make the case why their particular issue should be heard, and then the Supreme Court's clerks sift through the writs of certiorari and they choose a particular number of cases that they perceive as relevant to the Constitution. Per year, there's between 10 and 20,000 writs of certiorari. So the 9 judges and their clerks get 10 to 20,000 per year, like basically petitions or claims to hear the cases. And then out of that pile, they choose somewhere between 30 and 70 to make decisions on. So an extremely minuscule amount of cases the Supreme Court will actually hear in the courtroom. And that's called oral arguments, right? Where the sides of a particular issue will come and argue. And then based on the Constitution, the courts make a decision. And of course, the judges only decide to hear cases that have constitutional merit. A lot of cases have to come up from the state courts, federal appeal courts, state supreme courts are all areas where the cases can originate from. So when the judges decide to hear a particular case, they're really looking for a couple things. One, the ability to make what's called a precedent, basically to shift. Judges will typically hear cases that are compelling, that have a precedent. That's just basically a opportunity to overturn a previous case that the Supreme Court had made, or one that has great significance to society at large. So basically an opportunity to make new law. So an example of that would have been Brown versus Board of Education, which ended like school segregation, right? There used to be separate schools for black people, separate schools for white people, and a group of parents basically challenged that separate but equal is inherently unequal. And when the Supreme Court ended school segregation through Brown versus Board, they overturned a prior decision that their court had made many years back, 90 years back, right? So one consideration here cases is the ability to establish new precedent. Another is an opportunity to settle disputes between the states and the federal government. Often the feds and the states have conflicts, and that finds its way up to the Supreme Court and is likely for judges to hear. An example of an issue between the states and the federal government that found its way to the Supreme Court was it came out of South Dakota, actually in the 80s, and it had to do with the drinking age, right? Whether the drinking age should stay at 18 or move to 21. And South Dakota was one of the last holdouts. They refused to change their drinking age to 21. And then the federal government responded by withholding all their highway funds for the next year. And South Dakota said, well, wait a minute, you can't do that. You can't just withhold our highway funds. That's our own taxpayer money that we pay into. And the Supreme Court, you guys want to take a guess? Did they go with the state government or the feds? Of course, the federal government, right? And so the federal government won, right? And it said, yes, the federal government may use persuasive means, i.e. withholding their highway funds, in order to force a state to comply, right? So in the state, of course, South Dakota said, well, that violates the 10th Amendment. Not so according to the Supreme Court. So that's an example where the Supreme Court will hear a conflict between the states and the feds. Another issue, so precedent and hearing conflicts, settling conflicts between the states and the feds. Those are two considerations to hear a case. A third one, right, and we'll end here, is to basically settle conflict on a hotly disputed issue in the contemporary time, right? So one of the most famous decisions ever made and despised, right, by many conservatives in particular, was Roe v. Wade, right? And that was considered an extremely hot button issue in the 70s, right? So you guys know Roe v. Wade. That deals, of course, with abortion, right? And the federal government basically established the right for a woman to have an abortion in that case, which was considered super controversial at the time. The entire country was incredibly divided on that issue and still is. And the Supreme Court, of course, in that decision, they said, a woman has the right to an abortion. It's an extension of the 9th Amendment of the Constitution, which basically says just because you have a certain set of rights listed in the Bill of Rights doesn't mean other rights aren't implied. So privacy is one of those rights. Supreme Court said that women have the right to an abortion based on privacy. and that up to 3 months they're guaranteed access to an abortion, and no states may restrict that. Then after 3 months, the Supreme Court said the individual states may start placing restrictions on the woman, right? So that's how you end up with, California, you can get an abortion really up to 5.5 months, which many conservatives are like appalled by, right? But in other states, you can barely even get up to 3 months, in many of the southern states, which appalls many liberals, right? So we'll kind of end here, and we'll get into some hot button Supreme Court cases. I'll cover about 10 to 12 of them in our next lecture. And you guys be well, take care, and be peaceful.